Good morning, everybody. Welcome to the October Policy and Personnel Committee meeting. I'm Deborah Brooks, the elected chair. With me is my co-committee member, Sandra Alvarez, liaison, Dr. Shields, personnel, oh my goodness, PPS, Assistant Superintendent, Dr. Stephanie Allen. Mr. Howard Miller from our law firm is here. Javier from Central Office is here, and we have a community member. We are expecting one other attorney to join us, and Nanette Melkonian is participating via Zoom. She is out of the state. So, or out of the jurisdiction, let's say. Okay, with that, Dr. Shields.
Yes, good morning, everyone. So in the packet you have the minutes from our last meeting.
Those are draft. They haven't been approved by the full board, but they have been approved by the committee.
Correct.
Yes, okay.
And they will be on the board agenda for approval. For a personnel update, I think the only thing I'd want to share with you is that we mentioned to the board earlier in the year that we wanted to start to add a second security guard at the elementary level, and we would be doing that by replacing an EA when an EA left the building. So I just wanted to let you know we're in the process of doing that. So we'll have more of a security presence at the front door of our elementary schools. So that's going to take some time to do. But we're starting to phase that in successfully. So I just want to let you know about that. So we have Mr. Miller here today, who represents the school district on several legal matters, but is also very helpful in answering questions about policy. Last year we had started looking at the special education series. Dr. Allen came and met with the committee. There were some questions that had to do with policy 4321, which is being revised. So one of the outcomes of that conversation was that it might be helpful to have Mr. Miller here as part of the conversation. So we're not looking at the whole series, but we're focusing on the umbrella policy, which is the 4321. What the committee has as a reference is a chart that Dr. Allen put together last year that is, I think, a very helpful tool just for you to have as a reference, which is policies that we have in place and how they correlate with the NYSSBA policies, and also a few that we want to add that are not on the agenda today, but they are policies that we want to add hopefully this year. I would recommend that they be on an upcoming agenda.
Yes, we last spoke about this, I believe, in February, and we had this chart, and the chart is very, very helpful. And we had decided we were absolutely bringing the whole sub-series of those policies in. I think the mandatory policy is 4321, which we have. It just needed to be brought into the 21st century with the latest legal ruling. And we are going to be working on all of we will be working on the sub-series, but we really needed to get 4321 straightened out first. Okay, so.
Can I just ask a question on the chart? And it did come up in the last board meeting, and I did my best to explain my question, and I'll try to say it now, especially with Howard here, and then Dr. Allen, maybe if you can clarify. But at the moment of this given chart, are any policies or regulation not in place that are required?
The four highlighted ones, yes, are missing and required, yes.
So it did come up as a board discussion, and they said it will go to policy. That was like the final direction at the board meeting. Was my question is, for these four specific for the moment, and again, if this has to go back to Tuesday's meeting for a full board directive, but could these four go to Howard's office, get created by Howard, drafted, and then put on for a read so that they are put in place? Because policy does already have a long list for the year. So can those four specifically get put on for a first read, approved by the district, by the full board, if after the fact, because then we will be in compliance, right? Those four would be technically in compliance. Assuming Howard does an amazing job writing them, that if by chance he did not do an amazing job and it needs to go back to the board, it could go back to the board after the fact because we are constantly reviewing policies. So that was my question. I was
Yeah,
trying to not
Oh, good.
create it, go right away because the full board has to approve and the full board would know, well, policy committee didn't actually review these they may go back to policy. That's just a question on procedurally, is that an option? And then two, if it is an option, I know we as a committee would have to decide if we bring it to the full board again on Tuesday, but it was slightly discussed at the last board meeting, and the final decision was bring it back to policy to discuss.
So I have a response, and I also have a question for Dr. Allen. So my response is, because you did approach me about this beforehand,
Yep.
and I've been noodling it in my mind, and I was thinking, there are boards that don't have policy committees. So for a board that doesn't have a policy committee, this would have to go before the full board for approval without having gone through a committee. This is the type of thing where I imagine that Dr. Allen and Mr. Miller could work together to make sure that these four, well, first my question was, I know you say it's missing.
Yep.
Does that mean that the material that's in these sub-policies is not anywhere else in any other policies?
We don't have those policies at all.
So not even the wording or the requirements that are in there, it's not subsumed within
Correct.
some other policy?
Correct.
Okay, so I'm in favor, and I don't know if Ms. Melkonian can, well, we're actually the majority of the
I
board
was
here,
gonna say
right?
that, but I didn't want to throw in that.
But I'm in favor of letting Mr. Miller and Dr. Allen work on those four policies and making sure that they have the Port Washington personalities and philosophy. But given that our next board meeting is on Tuesday, right, and just a few days away,
Yes.
I would, either you can propose it to the full board or I would, but no pun intended, I'm all on board with letting somebody else do that work, that very technical stuff. And even they could just, we would see it, it would be on board
Yeah, of
docs, right?
course,
So
yeah.
we would see it before the board meeting, so we would have the opportunity to straighten it out or ask any questions. So you can pose that to the full board on Tuesday, I would say.
So as far as policy committee, assuming Annette is agreed,
It's our
agreeance,
recommendation.
yeah, our recommendation, so the next step would just say, because they brought it back to policy, so we're gonna bring it back to the full
Yes.
board and say policy did discuss just these four specific ones,
Correct.
because they are the missing ones.
Mhm.
And assuming the full board is good with that, then it would be moving forward
Yes.
for the draft. Okay.
Yes. Ms. Melkonian, you okay with that?
I am.
Good, wonderful, so it's unanimous.
There you go. And just to clarify also, it is literally just those four that are the missing zero, okay,
Correct.
Missing special education
for
policy.
special education, yeah.
What's also helpful is it goes on for a first reading, and then you have time between the first
Yep.
reading and the adoption if there's any edits that need to be made,
Yes,
and you're already in the process.
I have full faith.
and it seems that these are very legalistic kind of
Yeah.
things,
Yeah,
as opposed to philosophical, so.
we're not gonna be creating these from scratch.
Yes.
We'll have others
And-
that we've done.
Yes, and NISBA has them also, because these are NISBA's numbers.
Those are the NISBA numbers, right?
Yeah.
Yes, okay, good.
So should we look at 4321 to see if, what questions there might be for Mr. Miller?
Let's have some fun.
I'll turn it over to Dr. Allen.
Okay, Howard, one of the main, couple of concerns that came up last time when we looked at the sample policy, they're not page numbered, but 1, 2, 3. The two words of concern are homeless and then wards of the state.
Homeless is a term of art under McKinney-Vento. So,
Okay.
Yeah, so homeless is homeless. There's a concern about using that word.
Yes. So one of the suggestions I think that we talked about at the last meeting was using unhoused instead.
I would use homeless because that's what's used in the law.
Okay.
And so could we maybe drop somewhere, I thought I saw a footnote, oh yes, within the meaning of applicable state law. So it would be, within the meaning of applicable federal and state law, because McKinney-Vento is federal law. And
Yeah,
words of the state.
I think you could use that you're trying to track law, that these are not your invented words.
And Dr. Allen had a question about words of
Ward
the
of the
state.
state was the other one.
Yeah, that, I could take another look at as to whether we need that language.
Or I think we had the suggestion last time too of citing the actual legal
They cited the
statute that
yeah,
uses the term ward of the state or defines ward of
or
the state.
defined, right, as defined in law.
Can I ask a question, just as you're reviewing these words and the importance of these words? So that specific clause, because that part of it, and it comes up in a different part. So school districts, the overall essence of adding that is that school districts need to actively be seeking these students out. Because is it traditional that on occasion, these students might not be enrolled in the school district? So,
We
okay,
have child find obligations.
Yep.
And it's increasingly an issue where children are moving into our school districts, who may not have registered, we don't know them, and we need to try to find them and give them an education.
and especially pertaining to special education. So for me, the feeling from this part, and again, when they're referenced later, is to protect them, those individuals. So
Absolutely, yeah.
I understood, I don't think I was on committee, I don't think I was on the board when those words came up. But for me, those two words are legal terms, they are used. So I understand like the code of conduct with the culture and how we're using words. But if those words are used to protect those students, I find it really important that we keep the structure of the words so that there is no vagueness of the responsibility of the district to seek those individuals out. So I know of Word of the State, I've never heard it used in a different manner. So I understand like the nature of like what the committee is trying to do with like the concern of such like a drastic word of ward of the state. Same with homeless, but I don't find it in that sense. Like if one of us was discussing a student, we're like, well, that word of the state, obviously I think the context of how you use it, but for me, in order to really protect the meaning of who is protected and who the district has a responsibility to look into, I've never heard it, I mean, by all means, bringing up another word, but I have never heard of another word of Word of the State. Word of the State are children in foster care.
Yes.
Who are designated to the state, who don't have a legal guardian. So different from, in that responsibility, a foster child who has an adoptive parent, or, there's other students that there would be no obligation to really seek out because they already have a legal guardian. Word of the State is very specific.
So I appreciate your comments, and I think that by putting the words
Footnote.
in quotes
Yeah.
with either a footnote or just a parentheses, because you're saying that these words confer a legal status and or entitlement on these children, and we don't want to mitigate that or diminish it at all, so.
So a lot of the parents would not have any idea what their legal rights are for special ed services. So we want to find them and make them aware of that.
But also the district would.
The district.
So that it's this, and this specific clause is the district's responsibility.
Yes, it is.
To
Yes.
know these two protected groups need to be actively
Yes.
Sought out.
sought out,
Yes.
yeah.
Yeah, Congress put that obligation, child find, yes.
Okay, so, I don't know if McKinney-Vento, I don't know where words of the state appear.
Just twice.
It's a few times, yeah.
I meant in law, in
Oh.
state law.
Oh, for Word of the
So we would just
State.
need the reference, either the reference or,
Legal
because
setting.
McKinney-Vento is not referenced here, so we would want to add Vento, and I'll trust you to give us the citation for McKinney-Vento and whatever applicable words of the state law, so we have it as a cross-reference. Okay. Ms. Melconian, you all right with all that?
I am, thank
Okay,
you.
you'll chime in whenever you want us to so I don't check in with you every single time. You'll let me know if you have any objections?
I will. I'm just as a side note, I can hear you and Sandra and Dr. Shields perfectly. I have a feeling that's about seating, and I'm having a really hard time hearing Dr. Ellen and Mr. Miller.
Okay, they're at
That could be a
the
blessing.
they're at the further end of the table. But what they were
wanna move
saying,
that.
what we were doing was we were talking about homeless and wards of the state, and we agreed that we're going to drop a footnote or a reference to indicate that those are terms, legal terms, okay? All right,
Yes, that's perfect.
okay, great.
Thank you.
Because I know you had raised the initial objection, quote unquote, last year. Okay,
Yes.
next.
The next thing was, that I have in my notes, was under the evaluation of students with disabilities, there was some, we were gonna take out the term in that first sentence, first paragraph, I
For
should
free
say.
appropriate public education?
Yeah, the free appropriate public education.
So in other words, it would have read to initially determine a student's eligibility under the IDEA and Article 89.
Right.
And the reason that language for free appropriate public education was going to come out was because that is what is defined by IDEA.
Right.
So we just wanted to make sure, I guess you were asking Mr. Miller, is
If
it
that
okay
was-
to
yeah.
take that out?
Yeah.
Yes.
Okay.
Okay, good.
All right, then, the next part that I had for Howard is on the next page, under conduct of evaluations.
I got myself a little lost here. Here it is.
Got
Okay,
it?
great, got it.
Okay, second paragraph,
Okay,
first sentence, the racial or cultural bias. So again, I think we're trying to find a different way to talk about discrimination on terms of racial or cultural bias. Is there a different way to say that? Is there a federal or state statute, again, that pertains to using those particular terms of racial or cultural bias?
Or do we need those terms?
Right.
The question from the committee was, will not be discriminatory.
that should encompasses everything.
And should encompass everything, so
Yeah.
can we take out racial or cultural bias? Because racial, cultural bias, actually not Rachel, racial,
Doing the same.
my sister's name's Rachel, limits it,
That's,
right?
it's a limiting language when
It's
you want it
limiting
to be more
language.
broad.
Okay, so we can delete
We
it,
can take that out.
okay? good.
Okay.
Could it just be, well, I mean, it's not needed, but couldn't you just add on any protected group? We've constantly gone back of listing the groups, so why not list that it's all protected groups? It's not again, if it's not necessary, being discriminatory is all encompassing already, by all means, but
That raises an interesting question. Any protected group,
well, now
Any
are all
protected
protected groups in this sense. Yeah.
right,
Sorry.
right, or is it possible to discriminate against a group that's not enumerated in the protected group? But I'm not, I think just about everybody's covered in the protected group, but that's just me thinking off the top of my head. Do we need either will not be discriminatory or will not be discriminatory as to any protected group?
With the footnote of
Right.
the protected groups.
And you can do it that way. The way it reads though is pretty all encompassing.
Will not be discriminatory?
Right, yeah. I think, I think what you're trying to get is that some assessments have a disparate impact on certain protected groups because the way they're worded. I think this is a catch-all.
Just discriminatory?
Yeah,
Okay.
yeah.
This is going to go back to you anyway for a
Sure.
final,
Okay.
just to make sure that all the legal stuff is in there.
Okay, the next sentence too, Howard, in addition, students will be assessed in we were talking about adding native language rather than just language and form most likely to yield accurate information.
Typically, I see native language
Right.
as the term of art there.
Okay, and then the last part of that sentence, unless it is not feasible to do so, either deleting that or saying to the extent possible, practicable, something like that.
I would say to the extent practicable. For the most part, it really should be possible to do that. Given the diversity on Long Island, we may have to go outside of our staff to do these things,
Yeah.
but
Occasionally, right.
Well, so then the sentence would read, in addition, students will be assessed in their native language, comma, to the extent possible, semicolon. Otherwise, whatever language and form is most likely to yield accurate academic, developmental, and functional information. And we're again saying to the extent practicable?
I would take out unless it's not feasible to
Okay,
do so,
right. And then
because
it
you're
ends there.
covering that,
Okay,
yeah.
okay.
Can I chime in for a quick second?
Surely,
Can you hear me?
yes.
Okay. After our last meeting, it was brought to my attention that, and I'm not even sure what the substitute is, but I was informed that native language is no longer actually the way that is considered best practice, so I was wondering about that.
I always thought of native language as the language you're using really at home that the child is familiar with. But if you want us to look for a different word, we can, but that's how I always assume that.
So,
It was brought to my attention that perhaps children that live in homes with family that has a different native language, that's not necessarily a dominant language for particularly the child.
Well, you could do native/dominant if you want to be more inclusive.
or can we just do
You
dominant?
could do dominant. Or you could say in their home language. Or
Because their home language, again, might not be the
dominant.
language that they speak best or would demonstrate their abilities best.
That's why I thought native, because let's say you came here from another country, you're fluent in a language and you're living with relatives who don't speak that language at home.
Can we say dominant then? Is there another, excuse me, is there another way to say
Right,
dominant?
yeah.
Or the language most familiar to them?
Maybe
or-
the language with which they are most familiar.
Dr. Allen, is there something in special education that is?
That's what I'm looking at right now.
So I'm
Yeah.
Trying to see
go
if
as
there,
quick.
it's actually silent on it from what I'm seeing so far.
I typically see guidance use the word native.
Native, that's right. Part 200,
So
Isn't
what if
saying
we kept
anything.
native, but then put in parenthesis the language which they are most familiar?
How about preferred? That's not my
Preferred.
word, but I'm
Well, is
paraphrasing it.
is that accurate though? If it's my preferred language, but I'm dominant in English
Yeah,
for
that's-
testing and assessments?
yeah,
it does say native language in
Yeah.
Part 200, I just found it.
okay.
So assessments and other evaluations used to assess the student are provided and administered in the student's native language or other mode of communication and in the form most likely to yield accurate information on what this child knows and can do,
Yeah.
et cetera.
But I wonder if native, you could
Mm-hmm.
flesh it out a little bit to address Nan's concern.
But what Dr. Allen just read from the statute is not actually what's in this
Correct.
template. Because in the template, it's saying students will be, if we had native, students will be assessed in their native language to the extent possible.
I would,
To the extent possible is feasibility in terms of assessment, not regarding the student. But what Dr. Allen, what you just read is that to yield the most reliable information. And that's not part of in their native language, because
but it says.
as I'm reading this sentence, it's in the template, if they are assessed in their native language, then there's no requisite that that assessment yield the valuable information because of the semicolon. It really should be in whatever language and form is most likely to yield. That to me seems to be that's the most important part.
It was also
Right, because
gonna-
what this says, to your point, is native language or other mode of communication.
I also was gonna bring this up, and I think it's important that we do clarify this, because at the moment, the district has taken a screener and not done it in a child's native language. So it's in my notes that I was gonna ask about this part of the policy already. While this specific paragraph is on assessment, this policy in general did bring up the screener at the beginning. So for me, we have a document a policy that is listing a screener and then listing assessments and students with disabilities and specifying that it is part of policy that we give an assessment in the native language. But Port currently is offering a universal screener, not in the native language.
So this only pertains to the assessments for determining eligibility for special education.
Okay, so, and that's where I was gonna say, because it's in two different areas.
Right.
So the screener, the screener was listed in like maybe page 2, and then this other, this sub,
Conduct and evaluation.
yeah, so the evaluation part was separate. So just to clarify, this specific part is saying only evaluations for services.
Right.
Not to identify the potential need for services to get evaluated. The screener is just identifying students who might need
Or at risk.
further at risk.
Right.
So for me, I just find it really important to know what the legal term is on evaluations, because the district, again, I know it's two different things, but the district already proactively made a decision about the screener with native language. So if the regulation, the federal, state, is that the students for special education need to have it in their native language, I'd want it as much possible listed, descripted there, so that no district can really adjust or change that. So I don't know if that makes sense of like how much I went on a rant on that.
Yes, it makes sense. So my first observation is perhaps we tighten the title, the subhead a little bit. Maybe conduct of evaluations for determining eligibility for services.
Because if it was me, I'd go back and be like, you have a policy that you're not enforcing, but if it's stated there that it is for services, that is different.
So we can do that as opposed to screening, which is also an evaluation, right? And then, so then to get back to this, the sentence in question, then in addition, students will be assessed. So are we saying in their native language?
So that's
Or-
coming out of the regs.
Right, the
Yeah,
regs.
So we're tracking the regs, yeah.
Or whatever language and form is most likely to yield academic, developmental, and functional information.
Do you want me to just use the
Maybe just
list the
take it,
whole
list
thing,
out of
right,
the
list
regs.
what- Again, it says, are provided and administered in the student's native language or other mode of communication, and in the form most likely to yield accurate information on what the student knows and can do academically, developmentally, and functionally, unless it is clearly not feasible to provide or administer.
I'm good with that one.
Yeah.
The reason part of it also is that there's no wiggle room on the district's responsibility to yield the most accurate results, right? So
That's-
it's,
Yeah, that's tracking right
There
out of
has-
the, and you have an
yeah.
and,
yeah.
the and.
Right.
like
There has
the-
been debates on how students are assessed, and was it a language barrier or an actual disability? So this,
Well, then can we, because in my brain, because I'm not fluent in this area at all, but in my brain, what I'm reading is that the most important part is that the evaluation needs to yield the most accurate information. So can we highlight that the district is required to administer an evaluation that is designed to yield accurate To do this, the student shall be evaluated in the following way. Does that make sense? Does anybody, is that too wordy? Is
Dr.
that-
Nacisi?
I think both have that essence of yielding the results. Also, because we've gone back and forth so many times, I don't know if you added because in that one it said native language or form of communication.
Form of
Mode
communication.
of communication,
Dr. Allen
which,
added that.
again, for sign language purposes, I think that's stating that like at one point, maybe your native language was Spanish, but then you ended up learning a different language being your dominant is why maybe Nanette's bringing it up, but mode of like theirs.
Well,
Again, yield the most accurate information.
right, sign language is one good example. I'm just thinking of a student that's completely nonverbal.
Yeah.
So the native language might be Spanish spoken at home, but that wouldn't yield accurate information for that particular student. So, and catch-all, I think, is good.
And that's why I'm saying, in my brain, the most important part is the end result, which is yielding the accurate information.
Yep.
And to do that, this is what the district shall do. Can you wordsmith it that way, and then we can look at it, and, is that okay with you? You understand what I'm saying? Like, I don't want to yield the most accurate information to get lost.
Right,
That's
Yeah,
the end
same, and
sentence.
Right.
that's why
Right.
when it was all in red, I was like, wait a minute, that's.
Right, that's the most important part
yeah.
of the, absolutely.
Thank you.
Can I go back to something if you guys are done with that part?
Sure.
So in the upper paragraph, in that same section, something else is like catching my eye at this point, which didn't before. Third line, academic information for determining a student's eligibility for special education and related services. Is that the intent, or is it determining a student potentially having a disability requiring special education and related services? Is it,
Right,
student
so,
eligibility seems,
so eligibility is the way Part 200 breaks it out. First is eligibility for services, and then the second part is if you're eligible, these are the services you get.
that's such a weird word, rather than determining that they have a disability requiring services.
Right, but eligibility is the term of art to see if they're eligible. I mean, to be eligible, you need to have a disability as defined in the regs.
And by the way, I want to welcome.
Rachel, hi.
I apologize, I had a
That's
meeting this
okay.
morning that ran
It's
way
okay,
over,
It's okay, it's okay.
but it's
Well,
nice to meet
welcome.
everyone.
Welcome
Well-
everybody who's watching virtually.
Yeah.
Rachel just, from Mr. Miller's office has just joined us. Okay, I'm sorry, Nan, go ahead.
Yeah, so eligibility is just how they define the term. It's
Yeah, I'm trying to find it.
it's a term of art in the law. And just going back to Deb's point earlier, maybe you start the section by saying it's the policy of the district to conduct evaluations in a manner most likely to yield whatever, and then get back to the,
And then, right.
yeah, maybe so that says
That's
up
like
front
the
what you're
highlight.
trying to do.
Because then that isn't the goal to get services, right? The
yeah.
end goal isn't to find out if a child has a disability, the end goal is to find if that child qualifies for services. So that, like, I have the reverse mind of that one where I'm like, I want to know what my child's eligible, what services they're gonna get. Whereas some people, we view disability sometimes as not as important as what the service that is needed.
Well, I think
that
the
makes
word
sense.
needed is the most important. What's the need? What's the educational need for the child? And that these evaluations are supposed to really dig down at that. What can we do to help is really, as cheesy as it sounds, what can we do
Yeah.
to help?
So, and the second piece of that as we're talking is you may have, the eligibility is the important word because you could have a disability, you could have a diagnosis of ADHD. That doesn't automatically make you eligible. So
If
having
it's not
that,
having impact.
right, if it's not having the impact.
Yeah.
So that's why the word eligible over just being a student with a disability.
Nan?
Okay, got it.
Okay.
Yep, okay, thank you.
Dr. Allen?
Okay,
I'm not trying to rush you.
no, that's okay, thanks. A couple of times it came up, Howard, where it says student's parent, and we were gonna add and/or guardian. I think that's
Yeah,
okay.
I'd say maybe a legal guardian.
However,
Legal.
in the third paragraph, on the very first page, sorry,
Sometimes,
we
okay.
basically define parent to
Legal,
mean
because it could be,
birth or adoptive parent, legally appointed guardian, blah, 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 blah.
yeah,
And
so,
so throughout, I was actually thinking we
Right.
don't even need parent
Parent
slash
or
guardian, because we've defined parent.
Okay,
but I think I know.
never mind that one. No, that's okay.
So
But is the red not the one removed?
maybe use
that's
guardian instead of
added.
legal guardian.
Oh.
Rachel just corrected me that it's better.
Yeah, it's
Oh, wait, am I wrong?
No, Deb was just pointing out that in the front, in the beginning, we do define parent, which
Okay.
includes legal parent, legal guardian, so it's kind of redundant.
Isn't this still the common forms that we use for homeless and words of the state?
That's what the regulations still say.
Okay.
So that's probably
Well,
why.
Maybe
why
it's
it's
throwing me
also
off.
there.
I know it's
It
not.
seems antiquated.
So which
When
is
it's the word
antiquated?
of the state, I feel like we're back in like the
I mean, there's
1930s or
some
something, but
regulations
I
that are
think it's
still
still,
very
it's still, yeah.
antiquated the way they're written, so.
But defining parent, where it says here the word parent means, is that okay, or, because
That's what we do.
it's not just parent slash guardian? It's,
Free speech.
it expands and defines who a parent is
Okay.
in a legal term,
Means
in a legal sense, on the first page.
guardian.
Which we don't do anywhere else in any of our other policies. But I'm thinking that that's what parent means everywhere, right, but.
I'm not gonna make that statement complicated, but I'm gonna make that
But you're gonna do
statement
it?
complicated.
You can do it anyway.
So, a judge can appoint you educational rights, which in some of your policies, then you, as the education right holder, can choose what happens on anything education related. But you have a lot of policies in the district that have nothing to do with education, with extracurricular activities and whatnot. And the child's legal parent would still potentially have those rights. So parents in this definition is actually, doesn't hit everything of every single policy. So I made it complicated for other reasons, but for this one, one of my questions as you're looking at it, because it says a legally appointed guardian, generally authorized to act as a parent. So is that the terminology used when someone is appointed the legal rep? So for education rights, is it a legal guardian? The word guardian, I'm just wondering, is that the legal term used when you are appointed for education rights?
My understanding is guardian,
Okay.
yeah. What happens in the trenches on those things, we are often looking at court orders as to who has what rights to
Yep.
do what.
Okay, so then throughout, this definition is, again, this is gonna go back to your office before we put on for first read. But, so using the word parent then throughout the rest of this policy does not need the slash guardian.
No, because it's a defined
We have
term.
defined it up above, okay.
And then the last question I had was, towards the last page there, Howard, CSE or CSE subcommittee. I was suggesting it should read subcommittee of the Committee on Special Education, consistent with.
Okay,
So
where-
that's under eligibility determinations,
Okay,
right after where we were just talking about guardian.
okay.
It's in a couple of places.
Yeah, it's in a few
yeah.
places, this is where it starts.
Yes, and then it's throughout.
Keeps going throughout. So the first sentence under the eligibility says the CSE or CSE subcommittee will determine whether. You got it?
Oh, here we go, CSE or CSE subcommittee.
Or should it say, or subcommittee of the CSE? Or is
I
it?
see them be the same thing,
Okay.
but you have a different take?
No,
Yeah,
I think ultimately they mean the same thing.
Okay.
That's personal preference.
All right, that's fine. That was all I had.
Do you have more questions?
Two questions,
Go ahead.
two quick ones. Again,
Because I have
wasn't,
questions too.
I'm gonna assume it's, I know the answer, but I'm just gonna ask it anyways. The 5 days notice, is,
Where are we?
page 5. But I don't know if that's page 5 of this little document, it's page 5 of the normal,
It's both,
okay.
Page 5.
Under which heading?
Well, it would be, I will do better note taking of where to
Oh, okay.
reference stuff, but I wrote page 5.
Okay.
Well, wherever 5 days notice would be,
But you're talking about of the CSE meeting?
yes, so 5 days notice is traditionally what's listed. Legally is that
Yes.
the only number that a district can list, because it's not a very friendly number, so I'm just asking if And why doesn't it specify 5 business days? Is there any reason nothing lists 5 business days?
Earlier in part 200, they define calendar
Days.
days,
Okay.
school days, so it goes along again with the part 200, 5 days.
So no other district has ever done more than 5 days in potentially their policy? Like
Not
10
that I've
days?
seen, I
No,
haven't checked,
but
like 10 days.
So that's like bring it up to the
Practically speaking,
state.
we're really not forcing, if a parent says, I cannot be there, we're really not gonna force
Right.
that. Unless there's a real sense of urgency, and then we would try to accommodate a Zoom meeting or whatever we can.
So I'll leave that as is and I'll take it up with the state. Page
Yes.
6, federal,
But
not
you
state,
know,
not
you know,
even state,
sometimes
federal.
it's the parent that wants shorter, and we can agree to that.
Oh, Howard, I've never met a parent that wants shorter than 5 days.
I have.
Well,
Yeah.
emergency meeting, yes,
Yeah,
obviously I
yeah,
take that
yeah,
back,
yeah,
okay.
I'm just trying to find where.
There
that
is no
was in
reverse
here.
policy, right? There's no, the district has a right to a minimum of 5 days notice for an emergency. So
Nothing
that
works
doesn't
in
actually matter.
reverse. No.
Page 6, again, the age of 15 for planning purposes.
Oh, it's
Again.
under transition service or
Yeah.
diploma credential. You're welcome. Last sentence.
Again, safe to assume that is the legal minimum age, and Port Washington would have no reason to offer something younger than 15 in policy.
No, but I do think as you're going along, as practically speaking, where are we going, you know, for a child? So I do think it's discussed prior to that age.
The discussion start at age 12. The requirement on the document starts at the school year, actually, it's the school year in which the child turns 15. So we could add that clarification
Yes.
if you wanted.
Okay,
Yeah.
thank you.
In the school year. However you wanna watch.
And the same thing, just take it up with the federal, changing that one, yep, okay.
Just, opinion.
It's in, yeah,
is to start doing it too much before then, it becomes difficult, because even at 15, what do you want to do when you grow up?
yeah, of course.
Right, so there's a developmental piece to that too.
Well, those are your 2 questions.
Yes, thank
Okay.
you, sorry.
Ms. Marconi, do you have any questions before I ask mine? Nan?
I was remembering that under student evaluations, parental rights, consent, and notification, we didn't get into the weeds on it, but there was a lot of confusing language in that section. Were we going to discuss that?
Yes, so in numbers 1, 2, and 3, we had talked about making those bulleted points for consent
Correct.
and making it more understandable, I don't know another word, because we started to read through this, and you have special education training, Nan, and Sandra certainly understands it, and it was just confusing, the way NISBA had written this. And so we had talked about rewording, rewriting, not we, but
Right, I'll
Dr.
work on
Allen
that.
and Mr. Miller, and making them bullet points to make it very clear what happens if, what happens if, what happens if, what happens if.
Right.
Okay, so we'll do that for next time.
Howard, I can write some stuff up and send it to you
Okay.
first.
Yeah, right. Any other comments, questions? Nan?
No, I think that was all of mine.
Okay, so it's my turn now? So throughout, I see it says, students with disabilities. And I guess my question is it appropriate to say students with disabilities or a student with a disability? Or do we need it in, like, the language, I don't know if there's a legal term of art, but to me, students with disabilities, to me, it just sounded cold. I don't know how else to say it. As opposed to each student with a disability or disability/IES. I don't know how to say it, so I'm asking for guidance throughout. I mean, it's
It's
throughout
everywhere,
here.
yeah. I would, I think, defer to,
Yeah,
You
I don't
guys,
think it's illegal again.
Yeah, I mean, that's definitely preference. Student students with disabilities, student with disability,
It
either way.
does sound more
that is-
personal to say a student
Yeah,
with a disability.
right.
Yeah. More individualized, I guess,
And
a student.
is it student with a disability or student with disability slash IES? Because there can be more than one disability, but I don't know.
Well, yeah, I mean, you
So,
can be
yeah.
classified as
Say it.
multiply disabled, but I think
Correct.
if you just say a student with a disability
Okay.
Yeah.
would be enough.
Because they're using it here with the definition and the regulations in mind. So that's how they're using that, which means they could be classified under any of those classifications with any of those disabilities.
Part two hundred does
fine.
say student with a disability.
Okay, I like student with, to me,
A
the students
student, yeah.
with disability, it just sound, it just didn't.
So Deb, can I piggyback off that for a second?
Sure, why not? Go ahead.
Did you hear me?
Yes, go ahead.
So I've actually asked other professionals in the field, and the term often requested is students with disabilities, rather than even the term special education. So what I'm finding interesting about this document in that regard is that it starts off with programs for students with disabilities, and then the rest of the time they use the word special education. And I've brought this to Dr. Hines' attention before, that I even find that, the use of the term pupil personnel services, we're using language that perhaps parents aren't following. Do we need to be clearer and say, programs for students with disabilities is much clearer than what does the term special education mean? Like that's such an odd term, right? So would we be more accurate in reflecting the title in using that in the other spaces in the document where we use the term special education?
So, I agree, it's first, I don't like the term special education. It is what's used in part 200. It does define what special education is, and just to go give the definition, especially designed individual or group instruction for special education services or programs defined in this part. So it's actually referring to what is being provided. That's the term for it. Can we find a different way of saying it?
I think you can. So
Okay.
I mean, I think maybe what you do, because again, they use special ed in the regs, but you can clarify that special education really means educational programming and services designed to meet the unique needs of children with disabilities. So that's what, correct me if I'm wrong, but that's what we're really doing.
That is what we're doing.
But every time that special education is here, is listed, are we going to put in that phrase that you
I
just
don't think
said?
you need to, so I think if you define that up top, then every time,
Like we did
so
with
so
parent.
then.
You may
in the-
also want to do that for student with a disability also, so maybe you want to just add a short definition at the beginning for all of those terms, so that as they're used throughout the policy, parents understand
So then,
what they mean.
so then like where you have the bottom paragraph, the board also makes special education and related services.
Right.
Maybe it's take out special education, just say educational programming and services.
Right, or like PSD, Programs for Students with Disabilities, because we use, the IEP, and then we define it and just use SP or IEP services and services plan, and if we define it and then just shorten it.
I leave that to Mr. Miller and Dr. Allen.
Yeah, I think we can get at what your,
Legal.
what your concern is.
Right,
And-
so almost similar to how we define parent up front.
Yeah,
Okay.
yeah.
Like maybe a section on definitions for, special education, students with disabilities, now what a parent
Yeah.
is.
Just make it a little bit more plain language for, yeah.
in the fourth paragraph on the first page, there's a parentheses at the very end, and it says, refer to policy 4321.10, programs and services for parentally placed non-public
Yeah.
school students with disabilities. Excuse me. We don't have that. It's not a required policy, and also we don't have that policy. So I'm just asking if we want to have that policy, because if we don't have it, it can't be included in this policy, it can't be referenced. So the question is for next time, do we want to have that policy, and if so, let's make sure we bring it on. Excuse me.
Yeah, but that's this policy. So our programs for students that are parentally placed is part of our district plan, so we don't have a policy for that. I had a notation from last meeting that we actually took that out. I have a cross out for that, yeah.
Oh, okay.
Can you
If that's appropriate to
explain
take
what
out.
that policy is? What are parentally placed non-public school students with disabilities?
So when St. Peter's was open,
Say again?
best example, St. Peter's, when St. Peter's was open, a parent can place their student at St. Peter's, and that would be considered a student that was parentally placed, but still requiring special education services.
And per New York State's education law, Article 89, is the district have any obligation to that student?
Yes.
So if a school were to open again in the district,
So we have Vincent Smith,
okay,
and if a parent places from anywhere, we have what's called district of location responsibility. So if anywhere on Long Island, a parent decides to parentally place their child with a disability there, Port Washington is obligated to provide those services,
okay.
assuming the parent wants them. And that's where child find comes in, we do this whole child find with them. And then the district of residence of the student is billed back for the services.
And just to clarify, why do we not want this policy? Do you have it somewhere
It's not
else?
required, it's part of our district special education plan. So there is a section in our district plan that includes that. So there's nothing that says we can't have it. So there's nothing that says we can't do it or have it. It is already included in the special education plan, which is a Board of Ed approved document.
Can we then say that, refer to
Sure.
whatever the document is called?
Mm-hmm.
Okay. Okay. On the second page, the fourth paragraph, where it says, students with disabilities may not be required to take medication. This is just rephrasing on my part, because the sentence was awkward to me. Can we say instead, no student with a disability will be required to take medication as a condition for receiving?
That's accurate, and that's the law.
I was gonna say, the law does not allow you
Yeah,
to
no.
condition that
Can I
anyway.
say
So,
that?
Absolutely.
Yes,
Can I reword it to say?
yes,
Yes.
yeah.
Excuse me. Okay. Okay, number 3.
Same
that-
page?
Yes, on the same page. At the very end, it's referring to policy 4321.2.
That's one of the ones.
School-wide pre-referral approaches and interventions.
So our corresponding policy for that is 4321.8. And also,
Yes, so at some point, we are going to renumber everything to coincide with the NISBA policies, right?
that would be my
Okay,
recommendation, yes.
so we can leave this 43.21.2 as is. Okay?
But, like procedurally, if this gets adopted before the numbers get changed, then are we incorrect in the,
Yeah, and I was wondering that too, which is why I wrote correct number here, and I also wrote it on another page. I don't know what the best thing to do is, because I'm afraid that if we, I mean, our plan, our goal, our objective, not even our hope, our mission is to make sure this whole sub-series is adopted this year, and hopefully before 2025 even. And I'm concerned that if we leave the number as is, or we put in our number, I don't wanna forget to go back,
You don't forget anything, come on.
and then.
I don't care, I just didn't know, cause like if this specific one is the first one that gets adopted,
Yes.
not the other ones after the fact.
Yes, so, do you understand our conundrum?
Yeah, I mean, you can adopt it and always go back and just have one little amendment, changing the number.
I could put a reminder
We'll
email.
put a reminder,
Can I
okay,
ask,
cause I wrote a reminder here too.
if we're adopting these other NISBA policies
At the
or
same time,
at
then
the
you
same
don't need
times,
to.
can we just do
If you're doing everything at once,
resolution
you
And
just
to-
edit that same
Yeah,
meeting.
Yeah,
Yeah, can we just do a resolution
we'll
then
look at the
to
timing.
rename?
Yeah.
Alright, we'll look at the
Renumber?
time.
Yeah.
I've made a mental note here,
that's perfect.
so,
So it's going to 8, or it's staying as 2? Because 2 is the Port one and is 8 NISBA? Which one are we talking about?
Port is 8,
Port is 8,
NISBA
NISBA
is
is 2. So we have to move it to 8 at the moment, so this can be adopted first.
Yeah, they get it.
or what I was just asking Howard was,
Board could always
can we
just
do
waive
a
their
blanket
policies.
resolution to the board where we literally are just renumbering all the policies? We're not changing anything about the policy, but we do a
Just renumber.
resolution to renumber
Mhm.
everything at the same time that we adopt the other sample policies and then go back and change
oh,
as
that's a
we
good
need to.
idea.
Yeah, I just assume that this document, because we're all working on it right now, will be first adopted on a different, like, maybe even next week, based on, no, on Tuesday, and then the other ones might be the November, and reverse, November for this one, December for the other one.
And what Dr. Allen, what I'm hearing you saying is that we can adopt this one, I guess with the port numbers, and then there will be a resolution
Correct, on
when
the
the
next
sub
meeting.
ones are adopted to amend this main policy. So we'll just make sure, because, and then in number 9, where it says in red, in conformance with policy 3221.1, ours is 3120, oh my goodness, my dyslexia, sorry, 4321.9, I
Right.
think. So we just wanna make sure that
Point
all
Now
of
we're
our numbers
changing
are,
that one, and then the
we're gonna put in
resolution.
ports numbers for now, and then a resolution when the sub ones are adopted will allow us to go back without further ado to change the numbers in 4321, big blanket policy.
Right.
And then, let's see. We have under student evaluations, parental rights, consent, and notification, under that subheading, we were going to, I thought, insert the last paragraph under conduct of evaluations somewhere within the that notification section. So the last paragraph under conduct of evaluation says, the district will notify a student's parent of any determination that no additional data is needed and the reasons, et cetera, et cetera, et cetera. Does that paragraph, first we were going to clarify that paragraph. I don't know what that means, but I have that in my notes from February. And then I thought we were going to move that paragraph to the notification section. So I don't know where that paragraph belongs.
It seems like it belongs with the notification section.
And if it does, then no additional data is kind of like hanging out there, and I don't even know what it refers to.
Okay.
So I don't know where it goes. I'm just saying, can we make sure that paragraph makes sense and find the best place for it?
Maybe it does need to
Yeah.
go here with the conduct, it
It's-
actually may belong there because.
It's a very poor, I think it's a very poor summation of the regulations on NISBA's part. Because I do think it belongs there. There's a piece of the regulations under evaluations where at some point, if the district feels like it has enough information to make recommendations, they have to notify the parents and then give the parents an opportunity to either request additional assessment or whatever they wanna do. I think that's just a really poor summation of that piece of, that section of the regulations.
Can you undo that?
Yes.
And make it not?
Absolutely. Yeah, that's.
We read it, we just said, huh?
I agree, it doesn't, that was
Okay.
a poor
Um,
summary on their part.
Okay, thank you. Going back to the student evaluations, parental rights and notification section. We already discussed we're going to make it more understandable and make them bullets. But in number 2, it says, we had this question last time, if the district cannot document its efforts to obtain consent, we did not understand why a district would not be able to document its own efforts. That sentence didn't make sense to us. We understand why you not be able to obtain consent, but we didn't understand why a district would not be able to document its own efforts.
I think that's just the language from the regulation.
It's not, so what I've seen happen is a parent refused to consent. Once in my career, we actually went to due process to force it. Which is not the greatest thing, because the parent can then say, well, fine, but I'm not consenting to any special ed services,
Right.
so. But I don't know why it reads like that.
Right, like I can understand why a district might not be able to get consent.
And
That
then
I understand.
I don't want it,
What I don't
I don't
understand
like
is
the
why
word
a
will there
district
either.
couldn't document that.
You should be able
You
to
should
document.
failed effort, like why
um,
can't, so can somebody just fix
Really,
it?
it would be if the district can't obtain consent,
Right,
the district, and I would not will force, I would say may commence due process.
right, but you understand what I'm saying?
Well,
like-
but that part, Howard, refers to the reevaluation. It's not for the initial, so,
I actually wanted to point
yeah.
that whole section out. So in the regulations, you do not have to pursue due process under
Right.
any of these circumstances.
Right.
It's all may in the regulations.
Mhm.
NISBA likes to clarify things and make it very black and white in their policies, which has its pros and cons, but that's what they're doing here. They're oversimplifying based on what the regulations say, and that's probably why it's not coming through clear. And then if you want to be taught, if you leave the will language, you're going to be forced into proceeding to due process in the event that you can't obtain consent.
So you're gonna rework that.
Right, we're gonna, this whole section will be reworked and we'll work on that part too.
But what was sticking for me was,
Right.
why wouldn't the district be able to document its own efforts? Like, right,
It's
like,
not,
it
it's
doesn't make
not a
sense.
thing that you couldn't document your own.
Exactly, so you're gonna fix all this, right?
Yeah,
Okay,
yeah.
good. I was just like, just, make a note in the file, couldn't,
Yeah, it's not
couldn't
like
get
your
this.
arms are broken and you can't type.
Exactly.
So, yeah, I agree.
Exactly, thank you, okay. Under eligibility determination on the next page, okay, words. When it says the CSE or subcommittee will determine whether a student is eligible for special education-related services as well as the student's educational needs. So, how is whether a student is eligible for special education and related services different from as well as the student's educational needs? Like, what does as well as the student's educational needs mean?
So I
Isn't
think
that-
what they're saying is we're gonna first see if we can classify you.
Right.
Then if we do, what is the IEP gonna look like? I
Okay,
think that's what that means.
That's the way I take it.
can that be
Agree.
clarified then? Because,
And then you could say, well, you can make it 2 sentences. If the student is eligible for services, the CSE shall determine an appropriate educational program. Something like that.
can you,
Also,
can you
just,
provide, can you
Yeah.
reword that in your next draft?
I read that one also, and going into any CSE meeting for anyone, well, at this point, my son, well, actually determining eligibility, so if they weren't eligible, they can still, the educational needs could still be building level support.
They can
There's
be,
other
yeah.
outcomes than just
Well,
eligibility.
you can add that. It's not it becomes if the child is not deemed eligible under the special ed laws, you can add something about, I don't know who would then consider building level services, but the child shall be
I usually say,
considered
yeah, the building to consider building level
big services,
interventions.
yeah.
But that's how I read this, that's what that meant, as well as students' educational.
Yeah, it's a little ambiguous.
right.
So
Provide building levels for mandatory.
as well as, yeah, see, because that's what I first thought, well, maybe that means if you're not, but the CSE though would not determine the building level services. So I would like to break this out in more plain English.
Right, because the needs drive the program. I think that's what they're trying to say.
I think what they're trying to say,
Right.
yeah.
I think to Rachel's point before, they took about 10 pages of this part of Part 200 and put it in 2 sentences.
And, right, and what they're doing, I mean, if you really look at the regulations, it's split into two, like eligibility and services is split
Two
into
different
two.
things,
It's,
yep.
are you eligible, and then what services do you need based on, right, where the educational impact is. And technically speaking, every time you go to committee, you're making those two determinations. So that's why it's written that way, but again, without a detailed understanding of the regulations, that's not clear, so.
So can you fix this without making it 20 pages?
Well, without making it 20 pages, a little tough. We can make it concise.
Thank you. And the next paragraph, the CSE or CSE subcommittee may not determine that a student is eligible for special blah, 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 blah. Is it may not or shall not?
I'm looking in Part 200. Just see what it says. I think it's may not,
So it gives the district discretion.
correct. But I'm trying to find it, because I was actually just going through this on a case the other day.
And if you can't find it right now, you
Okay.
can come back. I don't need to put you under that pressure now.
Yeah.
Under Committee on Special Education, the members of the CSE and CSE subcommittee, it says will include. Does it matter whether it says will or shall?
I think again, those are just preferences.
Okay, but will it has the same mandatory,
It's will is mandatory, yeah.
so can it be must?
Part 200 says shall.
Shall,
Okay.
okay, that's what,
Although I think they're kind of interchangeable,
Yeah.
but it's better to track the language.
so then we'll change that to shall. Shall, okay. Oh, I'm sorry, shall is under which question?
The subcommittee shall include.
Shall include,
Yep,
okay.
Board of Education shall appoint.
Yep, okay, great, so I had that.
Membership shall include, it says, yeah, it's shall.
Okay. On the next page.
Deb, before you leave that page,
Yes.
Deb,
Yeah, yeah.
I'm sorry, I did have other notes that I forgot about. The paragraph above eligibility determination,
Yeah, the district will notify a student's parent.
really poorly worded, this entire paragraph.
Yes, we actually just discussed that, and they're going to rework it.
Oh, that one?
Yes.
Oh, okay. Oh,
Rachel's further
didn't like
from the
the
mic,
first-
so.
Yeah, essentially.
Yeah.
Yeah. Well, we're gonna switch out soon. Actually, I have to go, but
Yes,
we're
we're
gonna
almost
switch
done.
out.
Thank you, Howard.
Are
Thank you for
Are
coming.
you going to the
the one
NISBA
about
convention?
data?
Okay. You
Hold
are.
on, Ann.
I'll see you there.
Are you talking about the paragraph with data?
Yes,
Thanks, Howard.
Thanks,
yes,
I'll talk to you
and
later.
Rachel's going to clarify it and make it make sense.
No, I think, I'm not,
The sentences,
not the paragraph under eligibility determination.
I know.
The paragraph above.
yes, we just discussed it. And Rachel's going to
I
clarify
thought you were
it.
talking about the paragraph below. Sorry, I missed that.
I
Okay.
was,
that was like 10 minutes
I
ago.
was just talking about the paragraph below, but before that, I talked about the paragraph above.
Which Rachel in regulation for
Okay.
that part with the language in there, it says shall again.
It does.
Yep.
I promise you,
Okay,
we
I missed
discussed it.
that. Thank you.
Okay, you're welcome. So number 4, the bullet number 4 that begins, district staff will take any action necessary to ensure the parent understands the proceedings, including arranging for an interpreter for deaf parents whose native language, can I just say is not English? Instead of saying is other than English, is not English? Okay? All right, under parental consent for the provision of services. The sentence reads, "The board acknowledges that parental consent for the initial evaluation does not constitute consent for placement for the provision of special education and related services." I found the wording "for placement for the provision." It didn't, I don't understand it. So,
It's poorly worded.
can you fix that?
I can, thanks. This one. Oh,
Thank you. And those were my only comments. Okay, so, any comments on top of my comments?
I have a question procedurally.
We are bringing this back.
Back here.
Oh, yes.
Okay.
Oh, yes.
I'm just checking.
Sorry. Oh,
I'm
yes.
just understanding process.
Oh, yes, it is now with the attorneys and Dr. Allen.
Okay.
On
Coming
winged
back to
feet.
November.
On winged feet. Hopefully November, I don't want to give anybody a coronary. So,
November's fine.
great, November.
I'll make it happen.
I was gonna say, we could set up some time.
Yeah.
And then potentially would be December, which then, that may mean from now until December that the other ones,
The missing policy.
the missing policies may also be on
And for a first read.
On December,
Yes.
potentially.
It's very
Okay.
possible. Especially, yeah, so as regards to missing policies, so we have the NISBA templates and I love the organization, I really do, but I am finding.
You're on record.
I know, that's which is why I'm saying what I'm saying. I am finding that the newer policies that we are bringing in from NISBA just aren't exactly what we would like to adopt sight unseen as is. So I would ask the attorneys to be provided with NISBA's templates and also for the attorneys to have their own templates that they use and work with Dr. Allen and synthesize, or you may say NISBA's great, fine, run with it, but I would ask that going forward, especially since it's going to be on for a first read without coming to committee first, that it's as, these four policies are as tight and accurate and understandable as they can possibly be.
I shared those all with Howard yesterday, Rachel, but I'll send them to you.
Okay, thank you.
And then I think that does it for 4321. Okay. It is 11:15. I kind of thought this was going to happen. Unfortunately, I don't see us getting to any other policies today.
Well,
Yes?
I just had a question.
Yes.
I'm trying to find which one it was that I thought, because normally after special education, Dr. Allen leaves, but there was one other one that we were going through that I wanted to make sure I asked my question.
Okay, great. Which one?
Well, that's why I'm going through my notes, sorry.
For one of the special education ones?
Yeah, I think it's promotion and retention. So I just think with
Yeah,
both
okay,
the
sure.
special ed attorney
It
sitting
was the
here.
graduation ceremonies one.
Oh, yes, and the graduation ceremony. Well, my questions on the graduation ceremony were not as in-depth, but it was on the promotion and retention.
Okay, so let's go.
Should we try to do that one? Just, you're both here.
Is everybody okay if we go a little bit over?
5 minutes, 5 minutes. she's all
Go ahead.
good.
Okay, we'll do the special eds, I'm sorry, students with disabilities, specific questions on the promotion and retention of students, and then we'll bring promotion and retention students back for all the others.
Okay, and if there's 2 more minutes for graduation ones as well, maybe. Okay, so for the promotion retention, I know that you brought it back because the buildings, like all the principals everyone wanted to review that, right? This is this one.
This is back here because Ms. Brooks worked on this a little
We
bit.
also didn't get to it last time.
Yeah, we
so-
didn't get to it, okay.
The committee was gonna do some work on it.
Okay,
And then
got
bring it back to committee here.
And
And then
then
if you
got
gave
it.
me
Okay.
the green light, I would then bring it to administration.
Okay, so my.
So I have not done that yet.
Okay, so my only special education question would be for the retention. So it's listed in several places that it's based on the students' progress or students' grades, whatnot. It's not in a specific spot, but at any time, is there a reason where a student would be retained due to space issues, cohort issues, something that has nothing to do with the student where they are, but what the district has as an offering.
I don't see that scenario. Unless you can give me a for instance.
For instance, if I have a student that comes out of TLC,
Uh-huh.
which is a functional life skills class, and they're moving into RISE, which would be an academic program, we have retained students so that they have access to the curriculum at a different level coming in rather than the grade that they are assigned.
Right, but that's not about a space issue.
No.
But
No.
it's not based on the child's
Well, it
failure of
is.
grades, because like
Right,
the
no, it's not
wording.
based on failure, it's based on student need.
So
Yeah, that
my
sounds like
only-
what's
Right.
best for the program for that child.
Right.
Yeah, so I didn't feel that come across in anywhere
Okay.
of this, with the retention. So I don't know if there's a asterisk
Yeah.
way to like add that part into it.
There could be a section for special, or students with a disability.
Yeah, so possibly, maybe that's like maybe there's one paragraph of just students with a disability, because I wasn't sure with, it all felt based on stuff that I was like, wait a minute, I feel like I've heard of students being retained for other reasons.
The 3-year rule in special education. You can't have students that are more than 3 years apart in age.
That's the one I was
36 months.
referring
That's
to
what
on
I'm referring
space.
to.
Okay, so that
It's
is
not
the
really
one.
space, but it's based on the age limits of the child. So you can't have a student with it, if you're talking about a class with students with disabilities, that's mixed grade levels. There's no more than 36 months of a gap. So the oldest student and the youngest student cannot be more than 36 months apart in age.
I
That's what
understand
you're
that's
talking
law.
Right.
Is there policy anywhere that covers that law?
I
So
don't think so.
perhaps we add, so we can't cross-reference a policy necessarily, so perhaps add a section for students with a disability that summarizes that, and then we'll drop references.
Yeah, because
Cross-reference.
if I was one of those parents and I read this and my child was retained, I'd say you're breaking the policy.
I'll go through and just make sure that it's not. I don't think it's in another policy. It could be listed in the district plan.
Okay, or Rachel might know,
Yeah.
but I think that's great to highlight for parents. Okay, we'll bring that back.
So
Yes?
so this whole policy, makes, it makes me go in a million directions that I'm confused at actually what we're trying to accomplish with the policy. Because it, at certain points, reads that we're meeting individual needs as an educational system, and then in others, it's about meeting state standards. So it feels very disjointed to me. Maybe you can just tell me that I'm reading it wrong, and I'm fine if that's the case. But I don't understand what we're actually trying to accomplish with this policy, and is it required? Are we trying to talk about students with disabilities here? Are we trying to talk about students meeting our academic expectations? Am I the only one that's
So
confused by this?
it is a required policy.
Okay.
We have the policy, we're just bringing it up to date. I mean, we do have this policy on the books, we're just bringing it up to date. Right now, we were just going to try to address the the students with disability portion of it. We're not going to go into the whole meat of this policy right now. But that's certainly something to bring up for next time and, for us to think about before we come back next time. Because
Okay.
this is the NISBA, again, the NISBA template. And there is shaded area in the template that talks about what the education law requires. So between now and then, let's go back and, just review, it says, the law requires districts to notify parents of its policy on promotion, including how its policy was developed, et cetera, et cetera, et cetera. And so that's why we're doing this.
Okay. Okay. so
But for
we're
next
gonna look at
time-
this in a different way in November or whenever it comes back.
Yes. Yes, because we have Dr. Allen here right now, we're
I
trying to.
just asked the one
Yeah, we're,
specific quick
yeah,
question.
we went off agenda.
Sorry.
It's okay, it's okay, we're trying to
No,
take,
that's fine. Thank you.
okay.
Okay.
Um,
That makes it a little clearer to
all
me.
right, and so since we're doing this, so, Dr. Allen, do you have all the policies we were going to do today? Do you have the one for graduation ceremonies
Yes,
too?
yes.
So since you're here, so there are optional paragraphs, for students with a disability. And I'm finding a lot of the language redundant, so I don't know if these were either or paragraphs. So on the second and third pages where it says optional, and we haven't gotten here yet, but just for the future, when we decide whether we're going to add this optional paragraph, it talks about the students who have not yet met the requirements for a CDOS or SACC, et cetera, may participate, and then when they meet the requirements, they can participate in another graduation ceremony, so it seems as though they can participate with their graduating class, and then once that class moves on, they kind of are in a new graduating class, so they can attend 2 graduations, which I understand. And then the next optional language paragraph, I don't know if that's instead of the first optional language paragraph or the second, but it seems redundant, and I just didn't know which one to pick.
To
So,
clarify on that, just because I read it different for the CDOS and the SACC. I think it says you can only participate if you earned one of those. It's if you did not earn a high school diploma, but in lieu of the high school diploma, you earned the CDOS or SACC is when you're allowed to walk. And then because you earned the CDOS, you can walk, but then after the fact, if you later on earned your diploma, you have the second opportunity to walk.
Yes.
If the district allows. But in this last page, it's only if you earned a CDOS that you're allowed to walk, which is optional. Does that mean someone that didn't earn a CDOS could walk?
There's a section in here to address that.
The 9th grade cohort part? The 9th grade cohort, what time of their?
So
is that
that, the last sentence on the first optional paragraph says, students with disabilities who have
Yeah,
not
yeah.
previously participated in a graduation ceremony may do so at the end of their final year in school.
What page are you on? Sorry.
That is,
2?
yes.
yeah, it's the last sentence of that optional paragraph.
Yeah.
Oh, thank you.
So I guess my question is, there are 2 optional paragraphs. It just says optional. It doesn't say optional paragraph 1, optional paragraph 2. So to me, I don't know what these optional paragraphs mean. Are they mutually exclusive of each other? Because it seems to me that they're redundant. So I'm just asking for next time if somebody can make a recommendation as to which paragraph should be here, and if the wording needs to be changed, so we can run from there, since this is specifically for students with a disability.
The reason it gets confusing is because a student may earn one of those exit credentials prior to the age of 22. However, because they're a student with a disability, and correct me if I'm wrong, they are allowed to stay, and they may subsequently earn a local or a Regents diploma. So they may have done something else, and now you have a different situation. So I think that's why it's a little wonky in the language.
Yes.
I completely understand, so if you could just let us know, do these optional paragraphs belong in our policy, that recommendation? Do they make sense, and do they make sense together? If both of them are in there, do they make sense together?
Who decides, well, I know obviously the administration can give a recommendation, right? So I think a bigger question, not just, these are all optionals, right? So one of my biggest questions was gonna say, is the board deciding which route on some of these optionals? So like,
Oh, I see what you're
I
saying,
think,
right.
I would like a recommendation from the administration on what you've seen in practice, what you'd like to see in practice, and then based on that, that would help clarify what our policy is gonna be. But I was going through it and I was like, well, who picks when they get 2 ceremonies? What has happened in the past? So no recommendations actually been given on any of the options yet either, to just,
No.
to work on a policy.
Yeah, and to me, to me, the options seem the same, so I would just ask that when we come back, if somebody could help me understand how the options are different, because to me, the second paragraph is kind of saying the same thing as the first paragraph. So, unless
So-
I'm not reading it
So it
right.
sounds like you're saying, administration, take a shot at this policy
Yes.
and bring it back to us.
Yes, and, yes, and,
So why don't we do that?
Thank you.
We'll bring it back, and if you
Thank
have
you.
questions, of course,
Right.
we can work through those.
okay, great. Thank you.
Mhm.
Okay. All right, now we're really out of time. We have one community member left. Any other, I'm very sorry. It was very important we get through the special education policy. Very, very important. Knew it was a lot on the plate, but that's just how it goes when you have very thinking, meticulous people on the committee, right? And lawyers at the table as well, and so. Are we ready for community comments? Mr. Boyd.
Yeah, it's just a point that we made. Speaking of native language is one of those terms that I think we all know what it is, but at the same time, we don't know what it is. Because native language sometimes is not what it seems to be. The only determinants of proficiency in a language are being able to be, I don't know, tested for knowledge is being able to read and write that language. Because you will find a lot of students who are very, very verbal, they talk and they say, oh my God, I haven't been in education, we went through years, although that person speaks English perfectly, but it doesn't. So again, it's just to be aware of that native language. Like, if I can use myself as an example, my native language is not English, but it is my dominant language, English. I mean, I only think, sleep, and write and do anything in English, even though I'm very proficient in Spanish. So you have to think in those terms. And also, when there are certain terms in English that are not translatable to even your native language, that makes no sense. I see sometimes of the translations and I go, oh my God. You know, it reminds me of, what was it, Ford, when he talked about being pregnant. When he translate, I don't know if anyone is aware of that. He made a speech in a Latin American country, and he used a word for, to mean embarrassed, and he came out as being pregnant. So that is my term. I mean, there are a couple of other things. I think that the district, or the districts, and I think we have a lawyer here, the courts want to see good faith. The courts will allow a lot of discretion for maybe errors here and there, as long as there is good faith on the district to deliver services or whatever. And that is usually based on not being capricious and not being arbitrary. As long as you meet those and you have a good faith attitude, it will suffice. Slight changes in the law. Ultimately, what we get is the results. The results that
Yes, the
are fair
results
and
are
appropriate. Okay, thank you.
Thank you.
Okay. Okay, so our next meeting is November 15th, 10 a.m. here, again, another Friday. And we'll just pick up where we left off, I think. I don't know, and we'll try again. Now, given that the student harassment policy has been or will have been reviewed by council, I believe, before we come back, do you know if Mr. Miller will be back here, or is that TBD?
Well, let's see, I know you've had some dialogue back and forth
Yes.
offline about the draft of 0115. So let's see how we make progress on that. If it's
Okay.
helpful to have him back at the table, I will certainly ask.
Okay, great, okay.
Are we gonna do graduation, promotion, retention?
It's all gonna be back.
Okay, so with that said, will Dr. Allen be at the?
Well, if we're doing special education, I'll be here. I can stay for those two, that'll be fun.
We won't be doing special ed that day, though, right?
I thought we were gonna have it back in November.
Oh, okay.
Yeah.
We're gonna try.
Okay,
gonna
so it's going
try.
back, okay, so yes, okay.
And it's on my calendar, I just
Okay.
checked.
Okay, and if there, you know, if there's an issue or whatever, you'll let us know, but, and we'll try to really clean that up to get it on for a first read in December, but it's more important to get it right the first time.
Yes.
Take the time to get it right the first time.
Mhm.
Okay, all right,
Thank
great.
you.
So the meeting is adjourned, and we'll see everybody